They interfere with our wireless microphones here. And again, we appreciate you coming, and we'll start in just a few moments.
Welcome to the final arguments of the nation's first National Energy and Sustainability Moot Court competition. West Virginia University College of Law is proud to launch this inaugural competition as just one component of its comprehensive energy and sustainability program. This is an exciting time for West Virginia University College of Law and an exciting time to be the host of these final arguments. Today, we will hear the best and the brightest tackle a profound problem in energy and sustainability. We're very, very pleased to be able to play a role in launching this competition and hope that we will be seeing you back here in many years to come. This competition has taken several years to put together, and I think that it has gone perfectly well. On behalf of the College of Law, I want to welcome all of you here for this wonderful inaugural event. Thank you.
Good evening, ladies and gentlemen. My name is Jonathan Floyd. and I'm the Chief Justice of the Moot Court Board here at the College of Law, and we're very excited to have you all here with us. I'd like to give you a brief overview of the problem, and actually, if you'll look in your bulletin here, you'll see a much longer description. And I will not read it in its entirety. I'll leave that for you all, but I'll just give you a brief explanation that this case revolves around a company called Petrovita. And Petrovita is actually a medium-sized oil and gas company that in this case has entered into 2 leases to drill offshore of a hypothetical state. They spent $10 million each and signed 10-year leases to drill and produce oil from these sites. Unfortunately for them, there are 2 relevant clauses to those leases that has provided some sort of a problem. The first clause is that they will use the most advanced protective and safety mechanisms in all of their equipment. And second, that they will spend 25% of the money that they spend on producing these wells on sustainable and other types of energy production systems. As the economic downturn has arrived, that's caused somewhat of a problem of them putting forth that 25%. You can go through and see the rest. The petitioner will be Petrovita. The respondent will be the state. Per the traditions of the court, the petitioner, Petrovita, will have the opportunity to rebut. So the petitioner will begin with 2 gentlemen making arguments. Then the government will have a chance to offer their case, and then the petitioner will be available to rebut. Thank you very much.
Good evening, everyone, and thank you for coming. I'm honored to be able to introduce to you all today the competitors who, above all else, are what make this competition so special. We were blessed and very grateful to have advocates, competitors from across the country, and I'd like to take a moment now to introduce them all to you. I've had, again, the honor to sit in on almost every single trial that they've had, and today was a tough day. Because of that fact, I was as heartbroken as many of them were when they wouldn't advance on to the next round. When they arrived here, they arrived as the University of California, Davis and the University of Oklahoma, but they're leaving Morgantown as Keith and Ashley and Jeff and Cody and Dave and Nick. And I'm just so grateful, and we all are, to have been able to meet you and have you a part of our competition. So I'd first like to introduce our competitors who have come all the way from California, the University of California, Davis, Nick, and Dave. We were lucky to have 4 competitors, 2 teams, who came all the way from the University of Oklahoma, who were just absolutely outstanding and had made it into our Final 4 that we had earlier on today. So I'd like you all to meet Keith, Ashley, Jeff, and Cody. And last but not least, we were very grateful to have 2 teams from our own College of Law here at WVU who competed as provisional teams, or what's the term I'm missing here, exhibition teams. And they really allowed us to strategically plan the tournament and the bracket system that we had. They did a wonderful job. We are so grateful to them. Would you please stand up? Emily, Kurt, Benson, Steve Wolf, and where is Brian? Is not here. Please give them all a round of applause. All of the competitors put in so much time and effort. In addition to coming all the way to Morgantown to argue, preparation for this competition began many months ago when they had to research and write an appellant brief, which, having done a couple over my law school career, I can tell you is a lot of work. And the briefs were outstanding. They were graded by professors here, and a little bit later on in our program we have an award for the best brief. So if you would, just one more round of applause for all of our competitors. We are so grateful.
I promise I'll be the last speaker before we get this thing started. My name is Taylor Downs. I'm the chair of the energy competition here, and I'm the Associate Chief Justice on the Moot Court Board. Before I introduce the judges, I'd like to introduce to you our final round competitors. And as I introduce you, if you could come take your seats, please. The first people I'd like to introduce come from the University of Kentucky. They're representing the petitioner in this matter. The first individual is Jesse Parrish. Jesse is from Pikeville, Kentucky. He has an undergraduate degree in finance from the University of Kentucky, and he's in his second year of law school at the University of Kentucky. He is also hoping that Kentucky advances in the Final Four this evening, which he's hoping will. Yeah. The second individual from Kentucky is Peter Mascow. His hometown is Strongsville, Ohio. He went to undergraduate university at Ohio University and has a BA in history. He is in his third year at the University of Kentucky Law School and is hoping to take the Florida bar this summer. The second team that we have comes from Louisiana State University. The first individual I'd like to introduce from Louisiana State is Stephen Major. His hometown is Houston, Texas. He has a BA from Baylor in music and speech communication, and he is in his second year of law school at Louisiana State University. His co-counsel is Mr. Christopher Linto. Mr. Linto's hometown is Baton Rouge, Louisiana. He graduated with a BA from Chico State University and has an MA in clinical psychology as well. He is also in his second year at LSU with a focus on oil and gas, and he is married to his wonderful wife, Mary Ann. Last but not least, we couldn't have a competition without competitors, and we certainly couldn't have a competition without judges. If you turn to the insert, you'll see many of the judges that we had over the past 2 days. I particularly want to focus on our final round judges this evening. The first judge, and we will bring them in after we introduce them, is Mr. Larry Rosenberg. Mr. Rosenberg is a partner at a global law firm, Jones Day. Mr. Rosenberg is a litigator who has appeared before the United States Supreme Court as lead counsel in numerous matters. He focuses his practice in the areas of regulatory, statutory, and constitutional litigation, intellectual property, antitrust, international litigation, labor and employment, products liability, and securities litigation. He's also lead counsel for Chevron in a fraudulent breach of contract suit against the government. Mr. Rosenberg is the co-chair of the Trial Practice Committee of the American Bar Association's litigation section, and he is a principal author of A Practitioner's Guide to Appellate Advocacy. He received his J.D. from the University of Pennsylvania, where he graduated magna cum laude and Order of the Coif, and he received his B.A. from Cornell. Our second judge this evening is Mr. James Van Nostrand from Pace Energy and Climate Center. Mr. Van Nostrand became executive director of the Pace Energy and Climate Center in the spring of 2008, following a successful career in private practice as a partner in the Environmental and Natural Resources Practice Group in a large Northwestern-based law firm, Perkins Coie. In his 22-year career in private practice, Mr. Van Nostrand represented energy clients in state regulatory proceedings in 8 Western states, as well as proceedings before the Federal Energy Regulatory Commission. His practice emphasized electricity and gas regulation, utility mergers and acquisitions, telecommunications, and administrative law. Mr. Van Nostrand represented electrical, natural gas, and combination utilities in dozens of general rate cases and developed a specialized practice in the state regulatory approval and mergers and acquisitions, having handled several multi-state merger approvals in both energy and telecommunications industries. Mr. Van Nostrand has been recognized by the Energy Bar Association as Practitioner of the Year and is one of the best lawyers in America. Additionally, our third judge is Mr. Michael Penders of Environmental Security International. Mr. Penders is the chairman of Environmental Security International. He previously led consulting firms which conducted advanced investigations, helped develop standards for integrated environmental and security management, and tested their application in numerous critical infrastructure sectors. Mr. Penders led assessment teams at CL facilities in the private and public sectors. He has directed investigations into active terrorism, environmental crimes, industrial sabotage, and security risks around the world. He is a graduate of Cornell and Seton Hall Law School. Jonathan, if you could please bring our judges in and we will get this started. While they're doing that, we will have more thanks, but before we continue, I would like to thank the two individuals sitting in the front row, Dean McConnell and Professor Ann LaFaso. They have worked tirelessly on this with us, and this would not have happened without their work. So I really appreciate all of your help and all of your guidance and mentorship. Thank you. Enjoy the competition. Everyone here has worked extraordinarily hard, and I hope you enjoy it. Thanks. You're being serious. I don't. Everyone's friends are like
All rise. Oyez, oyez, oyez. All those who have business before this court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The court is now in session. Justices Van Nostrand, Justice Penders, and Chief Justice Larry Rosenberg presiding.
Please be seated. We're very excited for this argument. It is perhaps not going to be quite as entertaining as the Final Four, but I think you'll find it even more entertaining when you really think about it. Petitioner, when you are ready.
May it please the Court, Your Honors, opposing counsel. My name is Jesse Parrish for the appellant cross appellee Petrovita. This is my co-counsel Peter Masco. If it would please the Court, I would like to reserve 5 minutes for rebuttal.
Go ahead.
Okay. I will be speaking to the wrongful termination of the Site A lease agreement for 13 minutes. My co-counsel, Mr. Masco, will be speaking to the takings claims for 12 minutes. Would the Court like a brief recitation of the facts?
No, please go forward with your argument.
Thank you, Your Honor. Petrovita submits to the Court and asks the Court to reverse the lower court's finding that the Petrovita's non-performance of the renewable energy expenditure obligation should be excused under the doctrine of commercial impracticability. Second, we come before you to ask that you would affirm the lower court's finding that the government breached its duty of good faith and fair dealing in terminating the lease agreement in respect to the negligence claim. I'd like to return first to the performance of the renewable energy expenditure obligation that should be excused under the doctrine of commercial impracticability. Commercial impracticability is defined by the restatement, Section 261, when performance is made impracticable by the occurrence of an event, the non-occurrence of which was a basic assumption with the contract was made. In this case, the economic downturn in 2009 was this supervening event. In 2009,
are economic downturns foreseeable?
Your Honor, we don't stand before you today to say that, especially in the oil business, offshore drilling, that some measure of volatility is not to be expected. However, the decline in revenues was so significant that Petrovita was able to, with their own revenues, come forward with an operating cash flow number of only $5 million before seeking outside outside capital markets. This represented a 75% decrease from previous year's capital budget needs. This 75% decrease, Your Honor, I submit was not foreseeable and was not a risk that was assumed by either party in entering into this agreement.
Is there any provision of the contract that protected you from an economic downturn? Is there any provision that said, you know, in light of unforeseeable economic circumstances, Petrovita will be relieved of any of its obligations?
No, Your Honor. The contract is silent on to any of those specific conditions. Petrovita would submit to this court, however, that commercial impracticability should come in place of that silence to administer a fair result in this situation. Commercial impracticability is results additionally when performance is commercially senseless and all alternatives have been exhausted. Here, performance of the renewable energy expenditure obligation would have been commercially senseless. Again, I've spoken to the fact that the decreased revenues led to a substantially smaller capital budgeting needs. The oil business, and especially offshore oil drilling, is a capital-intensive process that must have certain capital expenditures year to year in order to keep and sustain current levels. We believe it is reasonable to infer from the record that the essential capital budget needs were met in 2009 without advancing further. It would be unreasonable to expect Petrovita to divert scarce capital away from their essential capital expenditure needs in order to fund new renewable energy technology.
Except that they had a contract that required them to do that, right? So, I mean, it's not senseless in the sense that they had an obligation. What you're saying is that because the downturn was so significant and capital was so restricted, we should excuse that under a common law doctrine.
Yes, Your Honor. We think it is reasonable to infer from the record. First of all, I would like to point out that Petrovita did continue to fund all existing renewable energy projects that had been funded in previous years. We think it's reasonable to infer from the record that Petrovita did not put capital to new renewable energy technologies in order to continue to fund the necessary capital budgeting needs of their offshore drilling rigs. It would be unreasonable to expect them to go ahead funding non-core business units in a time of such an economic downturn. I would also like...
Counselor, just a question. Are you citing only the macroeconomic impact as the basis for the commercial impracticability claim? Or are you citing more specific impact to your business? And are you citing any of the actions of the government as contributing to the commercial impracticability argument?
Yes, Your Honor. From the record, it indicates that it was a systematic economic downturn in 2009. A macro-level economic downturn is the reason for this non-performance to be excused from commercial impracticability. I would also like to focus the court on the traditional doctrine that equity abhors forfeiture. In this case, we have an offshore drilling rig that has been a multi-million-dollar project to install and to operate. Petrovita, in 1 year, has failed to live up to the renewable energy expenditure obligation. However, terminating the contract on this 1-year basis is a very heavy-handed result in light of the significant amounts of capital that were contributed to operating this rig in the first place.
How do you respond to the Seaboard Lumber case? That's the case from the Federal Circuit that said the contractor there was not entitled to a commercial impracticability defense where the non-occurrence of a slump in the timber market was not a basic assumption of the contract. How do you distinguish that?
Thank you, Your Honor. I think the Seaboard Lumber case is clearly distinct from the case we have here and the circumstances we have here. Seaboard Lumber case involved a fixed price contract for the price of timber. As you spoke about, Your Honor, when the timber market changed, the timber company was not allowed out of the contract. In this case, we don't have a fixed price contract or obligation. We don't have a profitability obligation. Instead, this obligation reaches further into the corporate treasury, further into corporate decision-making, and is a more intrusive obligation that acts on the capital budgeting and capital expenditure decisions of Petrovita. I think it is, or we think that this distinction is crucial in viewing it against other precedent. The Seaboard Lumber case, in this case, is entirely distinct and submit to you should not be relied on due to the different nature. I would also like to point out, to Your Honor, we would also like to point out that all alternatives were exhausted in trying to meet the renewable energy expenditure obligation. Petrovita applied for loans with multiple financial institutions when were denied, and were forced to accelerate the repayment of a note that incurred a several million-dollar penalty in order to meet its meager capital budget for 2009. The second ground for termination by the government was in violation of the no negligence provision of the lease. We would ask you that you affirm the lower court, Your Honors, in holding that the government breached its duty of good faith and fair dealing in terminating the contract under the negligence provision. Your Honor, we don't come before you today to ask that you say that the actions were negligent as a matter of law. We believe that's a factual question that should be resolved by a jury. We do think that question does not need to be resolved in order to show the bad faith or the breach of the good faith and fair dealing duty.
No, that confuses me. I thought the district court in this case ruled in your favor that as a matter of law you were not negligent. Am I wrong about that?
No, Your Honor. The lower court did not reach the question of negligence.
I see. So it ruled in your favor on...
Yes, Your Honor. Yeah. The lower court found there was a breach of duty of good faith and fair dealing without resolving the negligence issue.
So you were saying that only the negligence issue presents questions of fact. What about the good faith and fair dealing issue?
Your Honor, it is our contention that the breach of good faith and fair dealing stems from interpretation of the contract, and because this is an interpretation of the contract issue, it should be resolved as a matter of law. The duty of good faith and fair dealing presents two respective duties: the duty of honesty and fact, and the duty of commercial reasonableness of fair dealing. In this instance, the government violated the duty of good faith and fair dealing in two ways. First of all, established course of dealing between the parties dictated that upon citation of a minor act or faulty equipment here, that Petrovita be allowed time to remedy that condition. In fact, Petrovita was one of the top 5 safest oil producers in the entire Gulf region. In the 7 years of the lease agreement, they'd only been cited 7 previous times, and in each instance, Petrovita had quickly remedied the situation and not been charged with a subsequent violation.
They weren't using the technology that was most advanced, though, were they?
No, Your Honor, they were not.
Didn't the lease require them to use the most advanced technology?
Your Honor, we would submit that it does not require them to use the most advanced technology. The feasibility language from our reading of the 4 corners of the document would speak to an aspirational goal that they use the most feasible technology. The termination clause found later in the lease speaks to it can be terminated only upon acts of negligence. We believe the document is ambiguous as to the meaning of the term negligence, and so we reach out for standard tort doctrines of negligence to govern in this instance.
Do we know who drafted the contract as between your client and the government? Was this a standard government lease agreement? Do you know that?
No, Your Honor. I do not believe the record has that information.
Would it be relevant who drafted the lease?
I do believe it would be relevant because obviously an ambiguity may be construed against the author, but I do not know in this instance who authored the agreement. But the government as I said, breached its duty of good faith and fair dealing by departing from established course of dealing between the parties. Course of dealing would dictate that once a violation was notified, as in this case, Petrovita be allowed to remedy that situation. It's crucial to point out that although this explosion and resulting spill is a grave, it's a serious incident, loss of life, environmental damage, the spill itself, though, Your Honors, cannot be the basis for termination of this lease. It would have to come down to an act of negligence. And in determining that act of negligence, discretion would have to be used on the part of the government. This discretion is governed by the duty of good faith and fair dealing. The course of dealing between these parties informs this use of discretion. Petrovita should have been cited for this violation and allowed a time to remedy the condition. Instead, the lease was terminated, resulting in a substantial forfeiture to Petrovita.
Does the covenant of good faith and fair dealing actually apply against the federal government? Isn't that a common law doctrine that only applies against private parties?
No, Your Honor. I believe Syntax Corp v. U.S. states that there is a duty of good faith and fair dealing that extends to the government.
And what's the rationale for that? Why would that also apply to the federal government?
I believe when the government acts as a contracting party, as a party entered into the lease agreement here, they are acting not as a government entity, but as a market participant and should be governed by the same duties as other market participants. It is also crucial to point out in the Syntax case that impracticability was resolved to be a question of fact that should be resolved by the jury. That is the language, from Syntax.
But I thought your argument was that it was and should have been resolved as a matter of law as the district court had.
The district court, I was speaking to the wrong issue. In the Raython case, yes, the commercial impracticability should be resolved as a matter of fact. This issue should be, Your Honor, I misspoke, should be resolved as a matter of law.
Any questions?
Thank you, Your Honor. Thank you, Your Honor.
May it please the Court, Your Honors, opposing counsel. My name is Peter Masco, and I'm here on behalf of the appellant cross appellee, Petrovita. The judgment of the United States District Court for the Eastern District of Vandalia with respect to the takings issues should be affirmed for three reasons. First, the moratorium on oil drilling in the Gulf of Mexico has denied Petrovita all economically beneficial use of its property. Second, Tahoe Sierra does not restrict the application of Lucas because the moratorium is permanent in its effect. And finally, even should the moratorium be considered temporary, a taking has still occurred when the situation is evaluated on the ad hoc basis announced in Penn Central. The Supreme Court first recognized the regulatory taking in Pennsylvania Coal v. Mann, where Justice Holmes observed that while property may be regulated to a certain extent, if a regulation goes too far, it will be recognized as a taking. This is exactly one of those cases. The Court announced in Lucas that if a property is denied all economically beneficial use, the claimant should be entitled to compensation. Here, there is no economically beneficial use left in the property.
What relief do you seek on the takings claim?
Your Honor, we would seek that Petrovita be compensated under the terms of the lease for the remainder of the period and for the lost profits that we would be able to derive from the leasehold.
Would that amount be greater than $10,000?
Your Honor, the record is unclear as to what that specific amount would be.
Do you believe it would be greater than $10,000?
Yes, Your Honor, I believe that would be greater than $10,000 since it was a $10 million lease. 2 years are remaining on the lease, and if you prorate that out to $1 million a year.
Are takings claims of greater than $10,000 committed to the exclusive jurisdiction of the United States Court of Federal Claims?
Your Honor, I'm uncertain on that point.
Assuming that's true, then did the district court lack jurisdiction in rendering an award on that's within the exclusive jurisdiction of another court?
I suppose, Your Honor, if it was within the exclusive jurisdiction of another court, the court might have been out of line. Again, I'm not certain as to that applicability in this case, however.
Okay. Continue.
Thank you. As I was stating earlier, the court announced in Lucas that all economically beneficial use entitles a claimant to compensation, and Petrovita asserts that all economically beneficial use has been denied in this case. The only value that the leasehold provided to Petrovita was oil drilling. The moratorium instituted by the government has completely denied the ability for Petrovita to drill for oil on its leases. Although other rights were present in the contract, such as geological and geophysical explorations, the rights to drill water wells, and the right to construct renewable energy, with first respect to the geological, geophysical explorations and drilling water wells, those are only relevant in the drilling for oil. With respect to the renewable energy structures that would be permitted to be built on these leaseholds, it would be impossible for Petrovita to recover the cost of doing such construction within the 2 years remaining on the lease. Therefore, there is no economically beneficial use to which Petrovita may still put the property.
Counsel, can you cite a Supreme Court case where the Supreme Court of the United States either upheld or said a court should have affirmed a takings violation by the federal government, a regulatory takings claim?
Well, certainly in Lucas, the Supreme Court upheld a takings claim. I mean, that was where we got the per se rule that if all economically beneficial use was denied of the property, compensation was due. In that case, the court decided that compensation was due to Lucas because of the regulatory taking affected by the statute.
And what exactly was Lucas's circumstance in that case?
Well, in Lucas, the claimant owned property on the South Carolina coastline. South Carolina had issued a Beachfront Management Act which limited the ability of Lucas to construct the $1 million sort of resort that he wished to construct in that property. When that was taken to the Supreme Court said that all economically beneficial use had been denied in that property, and therefore Lucas was entitled to compensation.
And why is that case applicable here? I mean, we're talking about a moratorium that doesn't have a clear duration, so we don't know if it's going to be a complete deprivation, right? It could be, or it could simply be a moratorium that is lifted tomorrow.
Well, and I think you're speaking to whether or not the moratorium is temporary or whether it's permanent, and the rule of Tahoe Sierra and how it would affect this case. And if I may, I'd like to address that issue at this point then. In this case, the moratorium is indefinite. Although it was temporary in name at its onset, it is now extended into the future for as long as it would take if and until the government can remedy or find a remedy for the riser pipe problem, which gave rise to the moratorium. Because the moratorium extends indefinitely into the future, it has no sunset, it is permanent in its effect. In Tahoe Sierra, on the contrary, the moratoriums were temporary. They were limited at the beginning.
We don't know. It could be permanent conceivably, or it could end tomorrow. I guess the question is, what does the case law do with an indefinite moratorium, one that may not be permanent, it may not be temporary? Are there any cases that you can cite with sort of an indefinite time period?
There's no Supreme Court cases I can cite with an indefinite time period, but I would like to respond to that by saying two things. First, I'd like to point the court to Lucas. In Lucas itself, although it was a statute in play there, the statute ended up not being permanent in its effect. The statute was actually amended so that Lucas could have constructed what he would have liked to construct on the property by the time that course had reached the Supreme Court. So although it was permanent at its onset, it actually ended up only being temporary. I would also look at the Federal Claims Court case of resource investments. And in that case, the court identified 4 separate categories of takings issues. Those that intend to be and that are temporary, like Tahoe Sierra. Those that intend to be and are permanent, like Loretto. Those that intend to be permanent but are cut short, like Lucas. And those that are intended to be temporary but are effectively permanent. And I would submit to the court that that is the exact type of case we have here, where there is an indefinite moratorium.
And what did the Court of Federal Claims say about that last category?
Well, the Court of Federal Claims in that case, I guess with respect to Lucas, said that categorical taking was okay or was permissible with respect as long as if there was even some value in the property, so long as there is no economically viable use. The court focused on the economically viable use of the property. Because here oil drilling is the only economically viable use of this property, that purpose, that investment-backed expectation has been completely frustrated. The government cannot make any use of its property and is entitled to compensation under Lucas. And
Are you seeking injunctive relief in this case? I mean, are you asking this court to cease to halt the moratorium?
specifically, we are asking for compensation
Okay.
under the takings claim in the Fifth Amendment.
Could you ask for injunctive relief?
We have not presented that claim to the court in this case. Should the court not find that the moratorium, the indefinite moratorium here, is a permanent moratorium, Petrovita asserts that it is still a compensable taking under the Penn Central factors. Penn Central held that when evaluating a takings claim, the court should look at the economic impact of the regulation on the claimant, the extent to which the regulation has interfered with distinct investment-backed expectations, and the character of the governmental action. Here, the economic impact of the regulation is severe. I believe we have discussed this to some great extent under the Lucas inquiry. That is the prong of the test, which Lucas would be derived from here, because there is no economically viable use of the property. Petrovita cannot derive any revenue from it, and therefore it has a complete economic loss on its hands with respect to the leasehold. So moving on to the second factor, which is the interference with distinct investment-backed expectations, the primary expectation of this leasehold for Petrovita was to drill for crude oil. As I've stated, the primary expectation here to drill for crude oil is impossible under the moratorium. Penn Central itself has pointed out that the primary expectation may be significant, and the federal claims court case, again, Florida Rock Industries, has said that when 100% of the primary use of land is frustrated, there is a very large interference with investment-backed expectations. I submit to Your Honors that this is especially significant in light of the court's holding in Ruckelshaus versus Monsanto, which said that although the expectations must be reasonable, they can be, the severity of this analysis can be enough to overcome the entire Penn Central analysis on its own.
Counsel, do you believe it's reasonable that Petrovita would never face the risk of a moratorium? That was a reasonable expectation, and given the regulation of the oil industry, face the risk of a moratorium?
Your Honor, you are addressing the heavily regulated field doctrine here. And the way that plays out in this case is that it only applies when the regulation in question is foreseeable. In this case, a blanket moratorium prohibiting all oil drillings across the Gulf was not a foreseeable action. Although energy industry and oil drilling is subject to constant regulation and government intervention, that's more on the personal level rather than on the broad level. Here, where it extended across the Gulf, that's not something that Petrovita could have expected to lose its value on all of its leaseholds. And so we would submit that the heavily regulated field doctrine isn't applicable in this case. Moving on to the final Penn Central factor, which is the character of the governmental action, I would like to point out at first that this prong has been de-emphasized by the court in its recent decision in Lingle. There it said that because of the overwhelming nature, or there it said that if you look at the other two factors and they are overwhelming, this factor should not really play a part in the court's determination. It said that really this factor only may be relevant in a court's analysis of a takings issue. Generally, when looking at the character of the action, it's proper to look at the scope of the action. Here, rather than applying the moratorium to all coastal waters, the government has limited the moratorium to the Gulf. The riser pipe that the government seeks to have corrected with this moratorium, however, is in effect and in use across all United States coastal waters. The fact that it limited it to the Gulf seems to be somewhat arbitrary and goes against the character of the action. As I stated before, because of the overwhelming nature of the interference with the Petrovita's distinct investment-backed expectations here, because of the severity of the economic impact of the regulation, the Penn Central test tips heavily in favor of Petrovita. The government's indefinite moratorium on oil drilling has permanently deprived Petrovita of all economically beneficial use of its property in the Gulf of Mexico, and therefore it is entitled to compensation under the court's ruling in Lucas. Thank you.
We'll hear from the government.
Your Honors, may it please the Court. My name is Stephen Major, and today my co-counsel, Chris Linto, and I will be arguing on behalf of the government, the appellee in this matter. I will be discussing a breach of contracts claim before the court. My co-counsel, Chris Linto, will address the takings issue. The government's two main arguments with respect to the breach of contract are that commercial impracticability did not excuse Petrovita's conduct, and it did give rise to an appropriate termination of the lease contract, and also that even if a good faith and fair dealing covenant did exist between the parties, the government should not be found in breach of that covenant. The government requests this court to affirm the district court holding and uphold the appropriate termination of the Site A lease. Returning to the issue of commercial impracticability, federal and applicable state case law support the restatement position on the doctrine of commercial impracticability. And also, Your Honors, the Outer Continental Shelf Lands Act governs this lease. It does so because these leaseholds lie just outside of the coast of Texas. And
Counsel, for this argument, let's just assume that act does not apply.
Very well, Your Honor. And also in addressing the covenant of good faith and fair dealing, though mandated, the district court failed to apply an appropriate standard in determining that a covenant of good faith and fair dealing was breached between the parties of Petrovita and the government. For purposes of an appeals court, this court has the power to review these issues de novo. Commercial impracticability did not excuse Petrovita's conduct, and again did give rise to an appropriate termination of the Site A lease. If I may present a bit of an analogy for the court today, I would like for the court to understand this part of the contract in this way. The obligation for Petrovita to supply 25% of their expenditures toward renewable energy should be treated as a sliding scale. And, Your Honors, what I mean by that is that each year Petrovita had that obligation to spend 25% of their expenditures on these energy sources. In failing to do so, they reduced that expenditure to only 10% and affirmatively breached the provisions of the lease, specifically Section 5. Now, the sliding scale can be looked at is this way. If Petrovita chooses to spend $100 million in a given year for the purpose of oil exploration, drilling, etc., then simply it has the obligation to spend 25% concurrently in renewable energy sources. That figure is reduced as their expenditures reduce for purposes of oil and gas expenditures. Now, Petrovita would like to cite to difficulties in the economy and a downturn specifically that induced them to breach the provision of the lease.
So if they spent zero on oil production or oil exploration for a year, they wouldn't have to spend anything under the contract, right? 25% of zero is zero?
Your Honor, that is certainly correct. Unfortunately, we're not discussing whether or not Petrovita spent no dollars. In fact, they spent significant amounts in the years of 2009 and the beginning of 2010 toward the oil and gas production. What they failed to do during that time was comply with Term 5 of the lease.
Right, but the issue on commercial impracticability is, was this economic circumstance so severe that a rational actor entering the contract wouldn't have been able to foresee it? You would concede, wouldn't you, that this economic downturn has popularly been described as the worst since the Great Depression?
Certainly, Your Honor.
And do you dispute that?
We are not disputing that these are difficult times. I would like to speak with respect to the issue of foreseeability. The Windstar case, as provided by the district court language, says this: the parties will have bargained with respect to risks that are within contemplation of the parties and central to the substance of the contract. And if a risk is foreseeable, there should have been a provision for it in the contract. What we are asking this court to do is look within the four corners of the lease document. The parties had the chance to bargain for exactly what they wanted. And at the end of the day, they both signed off.
And that's a very fair point, counsel. But I guess the question here is, it wasn't simply an economic downturn that affected the oil industry. I think you'd have a pretty good argument if this were only, with respect to that. I think what their argument is it not only hurt the oil industry, but it was so pervasive that it affected the capital markets industry and made it almost impossible for them to get the kind of financing they needed to meet the requirements of this lease at a rate that was economically reasonable. And I guess the question is, isn't there some difference between something that's foreseeable as to the industry itself and something that's so pervasive that it affects all these other things that go into, the economic viability of the company?
Your Honor, you raise several issues, and I would like to speak to the reasonable efforts that Petrovita asserts they sought to accomplish by surmounting the obstacle to performance. What they did affirmatively do was try to accelerate the note on a previous banknote that was taken out, and they also attempted to apply for 2 other bank loans in order to comply with Section 5 of the lease. However, the government is not here today to present before the court what Petrovita could have done or should have done. Simply, I would like to refer back to the sliding scale analogy I used before and think of it as if Petrovita understood the difficulties of the current markets, which the restatement, the position they adopted, that Petrovita seeks to adopt as the standard for commercial impracticability, speaks directly to such conditions. Comments B and D follow. The market conditions and shifts along with financial situation of parties are assumptions that this section is discussing, and that even foreseeable events do not necessarily compel a conclusion of an event's non-occurrence being assumed. Comment D goes on to say, the change in degree of difficulty or expense does not necessarily amount to impracticability.
Counselor,
Yes, Your Honor.
there's only a couple more years left on this lease, and considering the moratorium has prevented them from realizing any revenue from these sites going forward, is there any connection between that and the government's claim to 25% of the revenue, or should there be?
Your Honor, I don't believe that there should be, and here is why. I'll speak to this also with respect to the doctrine of good faith and fair dealing and how the parties have essentially contracted. Again, I will refer to the lease doctrine as being express. Each provision was bargained for by the parties with respect to this 25%. This is something that doesn't just go away because of a difficult situation. This is something that both parties would agree is mutually beneficial to the government and also to the good name of Petrovita, essentially. And also, I would like to quote some other language. I would like to acknowledge Judge Rosenberg, as you quoted the seaboard lumber language earlier, stating that the slump in the timber market did not equate to commercial impracticability in that case, and that an economic downturn was viewed as not a good enough standard to apply the doctrine of commercial impracticability. The Raytheon case also held no commercial impracticability, Your Honors. Raytheon improperly assumed that when a contract specification called for extensive change, performance of the contract must be impracticable. Your Honors, I would now like to turn to the issue of the breach of the covenant of good faith and fair dealing as with respect to the past dealings of the parties.
You concede that that covenant applies to the government?
Yes, Your Honor. You did discuss earlier whether or not it applied to them as private parties or as the government, acting as the government. We certainly do acknowledge that the government is going to be bound by such a covenant. Now, the theory is suggested by the restatement, and the courts that are cited in the district court opinion will properly discuss a correlation between an acceptance of the restatement position on the doctrine. Now, the district court did assert this, that the covenant of good faith and fair dealing cannot be used to expand the duties of the parties beyond their contractual duties. Essentially, Petrovita is trying to make an assertion that their conduct, that the government's conduct, is not spoken to within the provisions of the contract.
Specifically,
No, what they're saying is that the covenant of good faith and fair dealing effectively excuses them from, language that is ambiguous in some way in the contract that could be used against them. And they're saying that, there's been this history of minor violations. The government has always allowed them a chance to remedy. And why is this different from those? Simply because people, wound up having to talk on the Oprah Winfrey show at the end of it.
well, Your Honor, here there's no ambiguity with respect to the language of the contract. Specifically, what opposing counsel for Petrovita did not seek to delve into before this court is that there is a non-waiver clause that is the final provision of the lease contract. Section 11 states that for any such avoidance to terminate a contract, to terminate this contract on a finding of negligence does not constitute the impossibility that the government can terminate the lease for a subsequent act of negligence. It is not our job today to present to you whether or not Petrovita was in fact negligent. We just would like to continue to discuss.
Well, Counselor, let me cut you off there. You cited the standard used by the court below for applying some of these principles. What was the standard used by the government in determining negligence here? Was there a requirement to adopt the best available control technologies, either by law or in the lease agreement, according to your interpretation? And please take into account that an incident that occurred less than a year before this, the government was content to make no finding of negligence and allow the petitioner to engage in corrective action without any finding of negligence on the part.
Your Honor, that certainly was the case in those previous examples of negligence that were found on the part of Petrovita. However, again, Section 11 is not ambiguous in any way. It simply states that those previous acts of negligence, however they were handled by the government, have no bearing upon any subsequent...
So is it the government's position that those were previously acts of negligence involved in whatever those minor violations were, that it was tantamount to a finding of negligence?
Your Honor, if we're looking to the four corners of the document, the lease document, it certainly could have been interpreted that those findings of negligence would have constituted an opportunity for breach. However, again, the provision found in Section 11 simply states that because the government chose not to act in those circumstances, that they were not barred from doing so at a later time. And so whether or not we acknowledge those instances as negligent or not, we are not disbarred as a government from terminating the lease at this point based on a current finding of a negligent act.
What I understand from the record, however, is this new technology for a better sensor diagnostic tool only came on the market a year ago, 2009. And whereas 30% of the industry have adopted this, 70% have not yet adopted it, including the federal government. And the federal government has a plan to implement it maybe by 2012. Would the federal government be considered negligent for not implementing this? Should something happen at one of their facilities?
Your Honor, fortunately for the government, we are not on trial today. What I would like to acknowledge, though, is that each situation is looked upon as a fact-intensive, case-by-case, situation-by-situation determination of whether or not it is appropriate under the terms of the lease to break the lease. And the government did have discretion under the terminology and the confines of the lease to, at this point, terminate the lease. Now, Your Honor, before I conclude, I would like to acknowledge the equity argument that was previously made by Petrovita. And I quote, "Equity abhors forfeiture." Perhaps it does, Your Honors, but equity in this case is found within the express terms of the lease document. Equity also abhors flagrant disregard of forfeiture
May I briefly conclude, Your Honor?
Keep going.
It equally abhors a flagrant disregard of contractual obligations. For these reasons, the government asks this honorable court to affirm the district court holding and uphold the government's justifiable termination of the lease contract with Petrovita. Thank you, Your Honors.
Questions? Okay, thank you very much, counsel.
Thank you.
May it please the Court, my name is Christopher Lento, and I represent the United States, the appellee in this matter. Your Honors, this portion of the argument is also based on federal statute which governs offshore leasing. Will we be allowed to touch on that, or should we confine our argument to the constitutional issues?
I'll leave it up to you, counsel. I mean, I would focus, if I were you, primarily on the constitutional issues. But if you feel like you need to talk about the statute, we're not going to penalize you for doing that.
We'll sidestep that issue then, Your Honor. Your Honors, this case is about Petrovita asking the court to, in essence, function as accountants in order to evaluate the value of a lease, to provide damages based on hypothetical production, rather than apply the common sense remedy of lease extension. Assuming that this case fell in an area that was not governed by federal statute, even under that circumstance, this is neither a per se taking nor a regulatory taking. Counsel for Petrovita asserts that the controlling case law here is Lucas. But in reality, in Tahoe Sierra, the test was outlined that the court should use to determine which controlling case law is used in the case of a taking. In Tahoe Sierra, the Supreme Court recognized that Lucas was a narrow exception for use only in the extraordinary circumstance of a permanent deprivation of all beneficial use. Since Petrovita cannot make this claim, the correct analysis to use is Penn Central.
Counsel, before you get into the merits of this, I have a few threshold questions. The first of these is, first of all, do you concede that the United States has waived sovereign immunity for this kind of a takings claim?
Your Honor, the court in Unical versus Morton held that when the federal government leases lands that it holds in trust for the citizens of the United States, it exercises the powers of a proprietor, but also preserves the use of its discretion to use its police powers. It's a balance that the government walks between a duty to promote the efficient use of the resources of the United States and the production and protection of the environment. The police power is subject to constitutional limitations. So to directly answer your honor, the government is subject to the limits of the Constitution, but still retains police power in the face of a severe public harm.
Yeah, but the government can't be sued unless particularly for money damages, unless there's a waiver of sovereign immunity, and that needs to be in a statute. And so the question is, what statute waives sovereign immunity here for the claim?
Your Honor, I'm unsure of that. The federal statute that we've used is the federal statute which establishes the only remedy for use in this case.
And which statute is that?
Which is the Outer Continental Shelf Lands Act.
Okay, so you say the sovereign immunity is there. Could it also be in the Tucker Act?
Yes, Your Honor.
Okay. And so the Tucker Act has been used to establish a waiver of takings claims against the government, right?
Yes, Your Honor.
Okay. Keep going.
Under the Penn Central analysis, the three factors evaluated by the court are the economic impact of the regulation, its effect on distinct investment-backed expectations, and finally, the nature of the regulation itself. The record here shows no evidence of Petrovita's investment-backed expectation. And since the moratorium only affects a small temporal slice of the entire lease, we have no idea if these expectations were met early on in the lease or shortly thereafter. Even if the court were to consider the lease itself as evidence of the company's investment-backed expectations, the company bargained for the terms of the lease themselves. A suspension is provided for under the police powers of the state, and the lease itself provided that it would be subject to applicable regulations. The district court correctly noted that establishing a regulatory taking under Penn Central is a heavy burden, and successful claims are the exception. But further, the district court noted that a party asserting a takings claim has the burden of showing an actual expectation of or reliance on the government not nullifying the contractual rights, and further that these expectations are reasonable. As both Your Honor and counsel for Petrovita have noted, this area is subject to heavy regulation, but moreover, the nature of the regulation itself, the comprehensiveness of that regulation, would serve to form the company's expectations. It would be unreasonable for Petrovita to assert that it did not expect to be subject to environmental safeguards enacted in response to a severe oil spill from its own leasehold.
How many moratoria on production of a widespread group of oil-producing lands have there been in the past? I mean, how many times previously has the government shut down a piece of the oil industry?
Your Honor, I'm aware of one direct moratoria in the oil industry on this part of the United States and one in the western.
And let's talk about those for a second. The one in this part was the BP?
Yes, Your Honor.
The aftermath of BP?
Yes, Your Honor.
As you know, that's in litigation and...
Yes, Your Honor.
Yes. What about in the western U.S.? What's the example you're thinking of there?
The Santa Barbara oil spill in 1969,
right,
which was similar to a moratorium under the Outer Continental Shelf Lands Act pre-amendment of 1978, where the government, the Department of the Interior was not provided with the option to cancel a lease, and the Natural Park Services was establishing a national park within sight of the oil rigs and decided not to extend a permit to the producers.
Okay, but what we're saying is when this lease was entered into in 2003, there had only been a single thing even close to a moratorium in the history of regulation of oil production. Why, given that very sparse history, would it have been reasonable for Petrovita to expect the government to shut down the oil industry in this part of the world for any reason?
Well, Your Honor, as the record notes, that the moratorium came when the government discovered that 70% of the operators in the U.S. were using faulty pipe casings. And that was combined, pardon me, Your Honor, they were using old technology, and that the pipe casings in use throughout the industry had the possibility of leading to another explosion and possibly a severe leak.
Sure, but they didn't know that. I mean, in 2003, they had no idea that these pipes were faulty, right? So they certainly couldn't have foreseen that there would be a moratorium based on the faulty pipes. My question is, given the history of one sort of analogous, maybe a moratorium, why would it have been reasonable for them to have expected that the government would have imposed a significant moratorium years later?
Your Honor, simply under the police powers of the state in the face of environmental harm, that it would not be unforeseeable that when an oil leak occurs that does significant damage to barrier islands and coastal wetlands, that there would not be a temporary suspension of operations.
Okay, well, that's a good point. You say temporary suspension. When is the moratorium going to be lifted?
Your Honor, the moratorium was classified as temporary from the point of enactment. As Your Honor noted, it may be lifted tomorrow, which would allow Petrovita to resume operations. In that sense, Lucas would not apply because the plaintiff has failed to adequately ripen its claim that it's been deprived of all economically beneficial use.
Right, but as the representative of the United States, I'm asking you, when is the moratorium going to be lifted?
Your Honor, the moratorium will be lifted when the manufacturer of the pipes discovers and allows for the implementation of a solution to the leaky pipe.
Do we know when that's going to be?
No, Your Honor. At this time, it's still speculative. Because Petrovita failed to ripen its claim that they've lost all economically beneficial use, Lucas would not apply, and again, Penn Central would apply. The Penn Central analysis deals with the nature of the regulation, and the moratorium can most accurately be characterized as a temporary suspension to minimize the risk of severe harm. Courts have held that when a regulation respecting the use of property is designed to prevent serious public harm, no compensation is owing under the takings clause, regardless of the regulation's effect on the property's value. So this does not constitute a compensable taking under the Mugler versus Kansas line of cases. However, there can be no doubt about the harm to the environment resulting from a serious oil spill. Therefore, we respectfully ask this court that the district court's decision be vacated with respect to their categorization of the suspension as a taking. Thank you, Your Honors.
Any questions? Well, I'll keep you up here for a little bit.
Yes.
Do you agree that, well, my first question is, do you believe that Petrovita would have had the authority to seek injunctive relief on the takings claim? Would that have been a legitimate portion of its claim?
Your Honor, they certainly could ask for injunctive relief, which would have been possibly a solutions that's more in line with their goals than asking for simple damages.
So you don't believe that there would have been any sovereign immunity problem if they'd asked for injunctive relief?
Your Honor, until the problem was mediated, we would certainly be up here litigating injunctive relief. What the government suggests is a simple extension of the lease, rather than ask the court to function as an actuary and try and calculate lost profits or try and value the lease as a whole, which the Tahoe Sierra Court specifically warned against doing. The government would ask to just extend the lease for an equivalent term of the suspension.
Okay, so that would be your solution. And do you believe that the district court had jurisdiction to adjudicate the takings claim in the way that it did? The district court didn't assess an amount of damages, right? It just simply held that there was a regulatory taking under the law.
Correct, Your Honor.
Okay.
According to the record.
So you would agree that the district court did have jurisdiction to make that finding?
Yes, Your Honor. I do. I agree.
Counselor, it's one thing to reasonably foresee and understand that you're subject to a highly regulated area when you enter into a contract like this. But the whole purpose of the contract was to realize value by drilling for oil.
Yes,
and so the subsequent subject of regulatory findings of negligence or contractual findings of negligence that is a moratorium within the scope of what they are undertaking in the course of this contract under the contractual provisions here. And given the course of dealing in good faith with the government on similar violations, how is a moratorium that prohibits them from realizing any value within the scope of what they understood they were taking on in taking on this lease?
Your Honor, the moratorium, per the record, is not based on findings of negligence. It's not based on the actual contractual agreement between the parties, but is based on a separate leasehold and based purely on the fact that 70% of the producers are not using upgraded technology, which would help them detect possible environmental damage resulting from faulty riser pipes that are in use throughout the oil industry.
Other questions?
Thank you, Your Honors.
Thank you. Petitioners, I believe you have 5 minutes reserved for rebuttal, and I take it you're splitting that somehow? Just, yeah, do it whatever, however you want to do it.
Yes, Your Honor. I will be speaking for 3 minutes, and my co-counsel, Mr. Masco, will be speaking for 2 minutes.
Okay. Go ahead when you're ready.
Your Honor, the government wants to rely on the four corners of the document to interpret all the problems that arise in this lease agreement. That simply cannot be done in this case because there are ambiguities in terms of interpreting it. For example, the first paragraph speaks of a 5-year lease term, whereas the term of the lease in Section 2 speaks to a 10-year term. There's an ambiguity and contradiction within the lease itself that must be resolved for going outside of the document. In this case, the ambiguity that we are resolving with common law doctrines is the use of the government's discretion to terminate the lease for negligence. That discretion should be governed by good faith and fair dealing. It's necessary to use this good faith and fair dealing standard to guard against the activities that are going on here. The government is essentially terminating a lease for alleged negligence when they themselves are using the exact same operating diagnostic equipment. It would be...
But the government didn't enter into a contract that said they wouldn't use that equipment or that they would use the best technology practical to avoid, a safety incident, right? You're the ones who entered into that contract.
Yes, Your Honor. It was not, but the termination clause does not speak to this feasibility standard. It only speaks to terminating based on negligence. And so looking at the discretion to terminate for negligence, we must go to some standard. The government couldn't point to a standard that they used to determine when to terminate. Obviously, the 7 prior acts were not sufficient to do it. So good faith and fair dealing must be that standard to govern discretion. Here, again, the government is saying that Petrovita breached their duty against negligence when they themselves were operating with the same equipment.
Counsel, do you believe that Section 11 of the lease is ambiguous when it refers to the non-waiver of previous findings of breach?
Your Honor, I still think that the Section 11 still speaks to discretion to terminate. Yes, it reserves that right, but it does not speak to the discretion to use to judge it. Some standard must govern the government's use of discretion. So Petrovita must fall back on good faith and fair dealing to govern that discretion.
To govern what the term negligence means.
Yes, Your Honor, and when to exercise when negligence. Not just when negligence is found to be in existence, but at what level of negligence will they act. In respect to the renewable energy expenditure obligation, I would like to speak to Justice Rosenberg, one of your questions, regarding foreseeability. In this instance, the capital expenditures are not just going to, I think it's reasonable to infer from the record, the capital expenditures are not just going to exploration and production, but going to necessary equipment maintenance and other capital expenditures in that sort. It would be a more unreasonable risk to, my time is right, may I finish? Thank you, Your Honor. It would be unreasonable to expect them to divert capital and to continue to use dilapidated equipment in the face of endangering further lives. The government must make up its mind here, Your Honors. They are asking us to spend more money to meet the 25% renewable expenditure obligation, and they're also asking us to spend more money to install new diagnostic equipment. Both can't work together in congruity. The government is showing no deference to the forfeiture that would occur by them exercising this quick trigger on the termination clause. I would close with, Your Honor, that we ask you to reverse the lower court's holding in reserve to the impracticability argument and affirm in regard to the breach of good faith, and close with a statement that equity abhors forfeiture. Thank you, Your Honor.
Your Honors, Petrovita asserts, and the district court found, that Lucas and not Tahoe Sierra was controlling in this instance because the moratorium is indefinite. Indeed, the Unical case, which the opposing counsels referred to repeatedly, itself said that if operations are suspended indefinitely, property rights have been taken. Here, the moratorium is indefinite. Counsel for the opponent himself is uncertain as to when the moratorium will be lifted, and the district court noted that a solution may not be forthcoming in the foreseeable future. Also, Petrovita would like to assert that because moratoriums of this nature in the Gulf have never happened at the time the parties entered into the contract, Petrovita's legitimate investment-backed expectations could not have been tempered with the expectation of a moratorium of this sort.
What about the government solution to just extend the lease term? What's wrong with that?
Your Honor, you actually bring me to my final point. What's wrong with that is, first off, that is a statutory remedy that the government wishes to cite, and that statutory remedy is actually only available when the suspension of the lease is done at the request of the lessee. So the statutory...
You didn't request that the lease be suspended?
We did not request the lease be suspended in this case, Your Honor, and so extension would not be available. Instead, that's a provision that provides that if the lessee would like to undertake its own environmental evaluations or technological evaluations, the government would grant them the permission to do that and would extend their lease. Instead, the proper remedy here for the denial of all economically viable use is compensation as entitled to Petrovita under the Fifth Amendment. Thank you.
Any other questions?
Just counsel, before you leave, I just, as counsel in this room can tell you, I'm fond of citing Justice Rehnquist's dissent in the Tahoe Sierra case. Do you think the dissent there provides any support for your position in this case as to whether this was a taking, a regulatory taking, whether it's temporary or permanent?
Well, Your Honor, I would instead refer to what the court said, I suppose, in the actual opinion of that case, where it noted that the moratoriums there had a definite beginning and had an end. That's different from the case here. Here, the moratoriums are indefinite. They extend forever into the future, and no one can say, not even opposing counsel, as to when they end. And I think because it's not within the borders demonstrated in that case, in the actual opinion, and not in the dissent, it should fall into the Lucas per se and entitle us to compensation.
Thank you very much. The case will be submitted.
Thank you, Your Honors.
That concludes our arguments. Would you please join me in congratulating our finalists and our panel. Our Chief Justice of our Moot Court Board will accompany our justices to their deliberation room where they can deliberate and complete their scoring sheet. So I ask that you all please rise.
Just say you guys can have, we'll have probably 5 minutes while they're deliberating. One more round of applause for our contestants, all of them. Thank you.
You know Butler's in. Yeah. Okay. He knows. So make sure y'all understand. Kentucky wins tonight. Expecting to have you on my side on Monday night. No bell on us. Cheer for Butler.
Excuse me, everyone.
You guys beat us, so we got to feel your lead. You knocked us out, so we can say, look, we would have won had we not been.
If everyone could take your seats, we do have a decision. I'm not on. Okay, it says it's on. Now it's on. Okay. Yeah, we have a decision, so next couple minutes we'll do some awards and get things rolling again. So thank you, everyone.
Yeah, but you had to say that when you're going against Ohio State. Oh, yeah. If you would have told me you guys had beat Ohio State, I definitely think you'd beat Connecticut. You did. Well, my final, I had Ohio State and Pittsburgh. And in my final four, I got the Lucas final where I had, well, I didn't have it. I actually had West Virginia and Tennessee in my final four. Well, I went under at a time. So it's in my heart, not my head. Clearly. And I almost beat San Diego State. I mean, they to make the Sweet 16, they took it.
Yeah, that's true.
So I rest assured, I'm the only person in the country around tournament do it every year that has West Virginia Temple in the final game. So 50 years from now, or if ever it happens, you will know that Larry Steve, that guy, your guy that was in the tournament, has won his bracket. Somewhere. You better hope he entered the million. That's right. That's right.
West Virginia Temple.
Yeah. It could happen. I think they're going to make you. Believe it or not. I think it's going to happen. He said he hoped that we didn't have to all rise and do that, but I think we're going to. All rise?
Please be seated.
All right, everyone. First of all, there are so many, before we get to the actual awards, there are so many people to thank this evening that helped us get this off pretty successfully, I think. The first people, if just anyone who's on the Moot Court board here at WVU could just stand up, because everyone in that organization really helped us out. If Dean McConnell, Professor LaFaso, and Professor Bowman could come up, we do have a thank you for you all. If I could have Mandy and Josh get them their thank you. And the other, one person's missing. Professor Bastris was unable to be here this evening. Professor Bastris, Bowman, and LaFaso took the time to grade all of the briefs for this competition. So we just, as a token of our appreciation, our awards this evening are, we found it fitting, they are coal mountaineers. They're made out of West Virginia coal dust. And without these individuals, first of all, this law school would not be what it is, and our competition would not have been what it was. So my sincere thank you to all of you. We greatly appreciate you. Also, again, you guys might as well just stay up here. To our final round judges, this was a great panel. We're very privileged to have you all here, to have the expertise in the field that you all brought to us. Thank you very much. I hope that you can take a little bit of West Virginia back home with you. I'm sorry if you have to fly back. We could probably get you a box to put that in. So thank you all very much. And before we get to the awards, there are just several other people we need to thank. First of all, Mr. Rosenberg and the firm of Jones Day helped us tremendously with the problem and getting this competition underway. So our sincere gratitude to you and your firm. Thank you very much. Additionally, Chesapeake Energy has been a very, very wonderful partner for the law school and helped us tremendously with this competition. We have a representative from Chesapeake who was also a judge, Mr. Gianni Diaz. Thank you for judging, and also thank you to Chesapeake for helping us with this. Last but certainly not least are the three law firms in West Virginia that gave generous donations to help us with our competition. And those firms are Bowles, Rice, McDavid, Graff & Love, Jackson Kelly, and Steptoe & Johnson. So thank you to those firms, and if there are any representatives here. And I'm sorry, that is not the last, but Margaret O'Bush, Brian Caudill, Lewis Mackley, and Keith Walton. Margaret and Brian have just helped us tremendously. Margaret planned all the banquets and has without all of their help, again, this wouldn't have been as successful. So thank you to Brian, and thank you, Margaret, I don't believe is here, but thank you guys very much. Now that I've taken your time and made you wait, our first award this evening is for the Best Oralist. And the Best Oralist Award was determined after from yesterday's rounds because all of the competitors were in yesterday's rounds. So the Best Oralist Award goes to Ashley Miller from Oklahoma. Just before we continue, all of the awards we will get personalized, so make sure that we get them back before you leave, and we will get a mailing address to send them to you along with a nice scholarship prize as well. The next prize is the Best Brief, and Ashley shouldn't have gone very far. Ashley Miller and Keith Needham, also from Oklahoma. Congratulations. Now I'm going to have to defer to the judges because I don't know who won.
Well, I'd like to say that we had a fantastic final round, and I want to thank the participants and thank the audience. I found out after we had deliberated that we had an all-SEC final here with the University of Kentucky and Louisiana State University, which is interesting in big East countries such as this. So if anyone wants to put some wagers on tonight's Kentucky-UConn game, I'm sure that can be accommodated. But I do think it was a great final round and very difficult to judge. But after careful deliberation, it is a unanimous decision for the petitioner, University of Kentucky.
that, that concludes our the first National Energy and Sustainability Moot Court competition. There are refreshments in the lobby. Again, thank you everyone who has been involved. I hope you enjoyed this evening, and I look forward to mingling with you all. For those of you who are worried about the Final Four game, it will be on the televisions in the lobby. So,
Butler was victorious over BC.
thank you all.